voluntary, as you say, program.
It's voluntary, yes.
We've got a mandatory Amendment 7 that requires patient access to adverse medical incidents, and a law that requires the hospital to keep that. So to me, it's even if they somehow decided to put it in there, when it's requested, they got to retrieve it. I don't know how these systems work. So I don't know that it's sort of like this idea that once it's this a report. Okay, let's just assume it was paper.
Yes, sure.
And you got this place to put it, or you got that place. So you decide to put it in a place that you think is more secure. That doesn't then, I mean, under what theory would that allow a privilege to be attached? Because you, the hospital, make a decision where you're going to store it.
Well, it should, and I agree with Your Honor.
But you seem to say it's illegal. That's what that for them to store it where they were storing it.
I think it is unlawful because...
But isn't that sort of beside the point?
Well, the issue is whether it meets the definition of patient safety work product under the federal act.
Right, and all I'm saying is sort of as a friendly question, I don't see how, where they decide to put it,
I agree.
determines that it's privileged.
Right.
Especially it's a voluntary program. Another hospital would have to produce it if they didn't participate in this voluntary safety program.
I would also suggest and urge this court to look through the record in this case and find a single fact, a single possible claim of wrongdoing by Baptist Hospital with regard to these circumstances. It is not there. For the first time in this Florida Supreme Court, appellants are not talking about the statute. They're not talking so much about the regulations. They're demonizing Southern Baptist Hospital for following the Federal Safety Act and the privilege it affords. And with regard to the statute and what it protects and what it doesn't protect, in the definition of patient safety...
You're talking about the federal
yes.
regulation.
Yes, Your Honor.
Okay.
Yes, Your Honor.
Well,
And
if the hospital has not produced documents that are required under state law and asserted a privilege with regard to all other records, the only inference to be drawn is that they are placing, if they're in compliance with the law, they're placing that within the statute, attempting to circumvent disclosure and to have it come under, I think they call it work product is the phrase there.
incident reports relating to the Charles family, we voluntarily removed from the system to provide. And so
you have the capability of removing, it's not like these are computer programs. It's not like this is a real box, like it's the size of the Supreme Court and you throw all these records in and you have to, right? You have you search and they're removed.
What we do is we put in there what Congress said we can put in there. Information that can improve patient safety, and the privilege applies. If we have to report it to the state, it's not privileged.
I guess, can I ask just a question what the trial court did, because we were talking about root cause analysis, but the trial court in this case ordered Baptist to produce all reports of adverse medical incidents as defined by Amendment 7, which are created or maintained pursuant to any statutory, regulatory, licensing, or accrediting requirements. And the trial court, maybe it was somebody's order, but said specifically that they're not PSWP if they're collected pursuant to a healthcare's obligation to comply with federal, state, or local laws or accrediting or licensing requirements. So this issue of whether they were burdened by producing too much or whether there was one particular root cause analysis that they shouldn't produce, it never got there. Right. They went up on the whole thing. They said, no.
They took a cert petition. Correct.